Please be seated. Bear with us because one of our justices wanted to take the secret door entrance into the courtroom.
They didn't pay attention to me in the last one. I'm just saying.
This is our last setting for today's arguments before the 7th Court of Appeals. It will be cause number 0725-00094, King versus Craig Senior Living. What says appellant?
Good afternoon, Your Honor. Matt Olivares for the appellant, Mrs. King. We are present and ready.
Okay. And what says appellee?
Jerry Fazio for appellee. We are ready.
Thank you. You previously been instructed that you will have 20 minutes apiece for argument. Appellant has an extra 5-minute rebuttal. And if you're ready, we'll begin.
Court, Mr. Fazio. Good afternoon, Justices. I represent Mrs. King. Mrs. King fell in February of 22. At the time, she was walking between two buildings in the ingress-egress area of the Craig, which was her employer. She was staying in a secondary building because she was a registered nurse during COVID at the time. A snowstorm had made travel to and from her residence back to the facility essentially impossible. And so the Craig, to make sure she could be there the next morning for her 6 a.m., 7 a.m. shift, allowed for her to stay on the premises. And so when she's walking between the two buildings, she steps up on a curb, slips on black ice. Essentially, the question becomes threefold. One, what was her status? The trial court granted summary judgment, essentially arguing or finding that she was a licensee rather than an invitee on the premises. Two, does the case law spurring out of Scott, Baylor, White, and Fair regarding open and obvious and the naturally occurring conditions of snow buildup affect the duty analysis with regards to the premises claim that Mrs. King has raised? And three, ultimately, is there an assumption of duty that can lead us to causation for the actual fall itself?
You said just a minute ago that when the Craig offered to allow its employees to stay for free because of the snowstorm that had come in, that was done for their benefit. Can you show me where in the record that is? Because when I read the summary judgment response, it said, you could have driven home. She answered, I wasn't going to drive home. And why weren't you going to drive home? And she answered, because it was so bad out there. My kids had called me and told me not to drive home. Okay. And then she said further, and since they were offering the free rooms across from my facility to the assisted living facility. I never saw anything in any of the summary judgment evidence to say that they were doing it for their benefit.
So from that area and in that area of the record, which is I believe around 87 and 88, it's pages 36 through around 40 of her deposition that's attached to the summary judgment response. In addition to saying, yes, she wasn't going to go home because her kids told her not to, she also says that the reason that she couldn't go home is because if she didn't go home, she wouldn't be able to make it back. So Mrs. King was a registered nurse in the COVID unit. They had one, short staff because of the COVID situations, but two, they were working 7 to 7 shifts. And so if she wasn't able to make it back to the 7 a.m. shift, there wasn't going to be anyone to cover that. It's a mutual benefit for Mrs. King and her employer because the only way that she's going to make it back, the only way they can actually serve their patients is if they have staff on duty and staff that's actually well rested because of the registered nurse and because their patients need people who are actually attentive. If she doesn't get the sleep or she doesn't actually come back, they're not going to have nurses who are able to actually serve their people. More specifically, though, the case law that's cited to specifically Perrenboom, but then also Wilson and Wong by the appellees, saying that once Mrs. King clocks off, she becomes a licensee rather than an invitee. The reason why that's important is when we're looking at premises analysis or premises liability analysis, Mrs. King in the record is going to show that she knew that it was slick outside. She knew that there was ice there. She knew there was snow. If Mrs. King is an invitee, her knowledge of the condition doesn't preclude her from actually recovering from a premises liability case.
Why is that the case? If the invitee, if the duty to an invitee is a duty to warn or a duty to make safe, isn't the duty to warn satisfied if the person has actual knowledge of the condition?
Well, when there's a necessary use exception, when she has to use, that's the only way she can get from building 1 to building 2. The necessary use exception allows for us to get around her knowledge or her awareness that would then alleviate the duty to actually warn. There's no dispute that the only way between these 2 buildings was this walkway. And so she was trying to take the safest route on the walkway, but more importantly, she had to go from building A to building B, and that was the only way to go. So because there's a necessary use exception, and Austin versus Kroger in 2015 acknowledges that the necessary use exception it applies because of the way the non-subscriber law is nuanced, and it limits affirmative duties that the defendant or the premises owner can raise. If she's an invitee and there's a necessary use, then her knowledge doesn't preclude her from recovery. If she's a licensee, though, her knowledge would preclude her from recovery. So that's why it's essentially the first issue. And because we look at Perenboom, so Perenboom says, yes, she went off duty and she became a licensee, but the reason she became a licensee is she left the facility. So she left the facility while she was waiting for a ride. She wasn't waiting in the designated area. And then she went so far as to leave not only the facility, but go behind the building into behind the dumpster area where she was not only not supposed to go, but it wasn't foreseeable that she would have gone. And then she actually became a trespasser. So her status changed 3 times, but it changed because of where she went and what she was doing. In Perenboom, it says, and the Supreme Court said in 2015, if it's foreseeable or if the individual is off the clock, but her presence on the premises is still done in a foreseeable way, but in a foreseeable way where it's at the instruction of her employer, then she doesn't necessarily lose the invitee status. She can still maintain the invitee status even though she's off the clock. But more specifically, if you look at the 1933 case for the Texas Employers Association, it's a workers' comp appeal, but it's instructive because what it addresses is course and scope. And when we talk about course and scope, if an employee is within the course and scope of their employment still, then they're still going to be an invitee because they're on the premises for the benefit of their employer. So the Texas Employers Association case, the issue was whether or not when an individual, whether they were on the clock or off the clock, in this instance, the injured worker was off the clock, if they were in the course and scope of their employment when they were using the ingress, egress of the actual building for the employer. The Supreme Court said, yes, they are invitees, they're in the course and scope, because the only way they can get to work or go from work is to use the ingress and egress.
The question of whether an employee is acting in the course and scope of their employment is a fact-driven inquiry?
It's a fact-driven inquiry, I would believe, because more importantly, it has to address with 2 things. 1, are they actually doing something for the furtherance of their employee, or for their employer? But 2, more importantly, to be an invitee, they either have to be doing something for the furtherance of their employer, related to their employment, or for the benefit of their employer. Those are fact questions within the purview of the fact finder. Those aren't questions of law. And because Perenboom's not on point, we then look at Wilson and Wong, which are both medical facility cases, where they find that an individual who's walking to the parking lot or walking away from the building facility is an invitee, is a licensee, not an invitee, because of their status of they're not benefiting the actual facility itself. The problem with that, though, is those cases are distinguishable because 1, both times Wilson and Wong aren't employees of the actual facility. But 2, the reason where they're walking or why they're walking and their presence at the facility isn't for the benefit. They're there to see family members. They're there to see or visit guests of the facility. If they were the guest of the facility or they were actually getting medical treatment at the facility, they would have been invitees. But because they're there just to see people and the benefit that's realized by the medical facility itself is realized independently of whether Wilson or Wong were on the premises, they start off as licensees. Wong actually becomes a trespasser because they cut across a field to get to the parking lot, which is one where they were not instructed to go to, but it wasn't foreseeable that they would have used that path because it was not a path that was made for walking. It was actually just a field between the buildings itself. Here, Mrs. King's actually using a path that she was instructed to go to, but it was also one that she could only use to get to where she needed to go. Looking at the Scott and White and Fair case, and then the numerous cases that the appellee cites to regarding the natural causing conditions and the natural buildup of snow, and whether that becomes an unreasonably dangerous condition, because 1, it's open and obvious, but 2, it's naturally occurring. That directly attacks the duty analysis from Mrs. King, right? So In those cases, they say that the natural buildup of snow or ice, or even the reformation of snow and ice, alleviates duty because it's, one, naturally occurring, so it's not unreasonably dangerous, but two, in most cases, it's open and obvious. The problem with those cases is, one, it doesn't address whether or not, those cases aren't from a non-subscriber point of view. And the reason why we focus on
So they're not what?
from a non-subscriber point of view. So Scott and White's a patient or a patient's family member who's walking back. The other cases specifically citing to that and building off of that are either residents or they're other guests of the facility, but they don't have employer status.
Why would it matter whether they were a non-subscriber for purposes of defining the legal duty? I understand for purposes of, there's no comparative, negligence and things like of that nature, but if we're simply looking at the scope of the legal duty, why does it matter if they were non-subscriber or a subscriber?
Because through the non-subscriber status, while comparative negligence is one of the affirmative defenses that is precluded by the labor code once you have the non-subscriber status, there's also other affirmative duties there as well. And one of those affirmative duties there would be the open and obvious. And the analysis from Scott and White and the analysis from the cases that build off of that progeny is that it's not unreasonably dangerous because it's a naturally occurring condition that's open and obvious to everyone. Because open and obvious, if you look at the Austin Kroger case, is not necessarily an affirmative defense that a non-subscribing employee can access, those cases aren't on point. But further, what's been ignored or what...
Do those cases frame open and obvious within the context of comparative negligence of the plaintiff? Or do they compare it, or do they put it in the context of there's no legal duty to warn of open and obvious defects on the land?
So Scott and White starts off with saying there's no legal duty for open and obvious because it's naturally occurring. But then the progeny takes it further, developing it into an idea of it has to do with comparative negligence. It has to do with comparative analysis, because the reason why there's no duty to address naturally occurring conditions is because they're well known to the parties. Further, though,
I've read Scott and White as not to go towards the duty, so invitee licensee wouldn't matter, but more towards the element of it's not a dangerous condition, just a natural ice. So do you disagree with that?
So
I wouldn't even look at the licensee or invitee. It's just natural occurring ice is not a dangerous condition.
I disagree with that to a degree, and the reason why is, so when we look at duty, we can look at it in two ways. One, what is the specific what is the specific duty we owe to a class based off their status? But two, does a duty even exist, right? So when you look at invitee versus licensee, that assumes that there actually is a duty. When you look at Scott and White, they're saying a duty doesn't exist because it's open and obvious and it's naturally occurring. The problem with that, though, is one, when it's open and obvious and it's naturally occurring, the reason why there is no duty is because the knowledge or the assumed knowledge, the presumed knowledge of the individual goes into that causation or that comparative causation analysis, which is precluded by affirmative defenses. The reason why this case, though, is sufficiently distinguishable is there was overt acts from the Craig's administration and maintenance group where they were telling Mrs. King as well as the employees, not only do we know that it's slick outside, but we're going to go and fix the sidewalks so that way when you're using the sidewalks that they're safe.
Yeah, so I understand you. We're talking about the email that got sent out, and I don't know if there's any other evidence in the record, but the email that I see is one that was sent that morning, 10:43 a.m. on February the 3rd, and the question had been asked, the sidewalks at WF, which I'm not sure what that means, and our front entrance need cleared off, please. And ultimately, the response they get back about 8 minutes later is either myself or my floor techs will clear it the best we can. Grounds has their hands full.
Correct. And then Mrs. King, it's in court record 87 to 88, she talks about they took that email, the administration did, and they started to circulate that saying, look, we've already notified grounds crew, we're working on it with grounds crew, it's gonna be taken care of when y'all are walking in between the buildings. So yes, the email itself by itself doesn't show necessarily that they undertook or made representations that they were going to undertake it. Mrs. King's testimony, though, which is part of the summary judgment response and is what's addressed within those 2 court record pages, is that they took that email that she didn't even know about and they started circulating it around and notifying the different members of the staff, look, we're addressing it, we've already got maintenance on it, they're working on it, it's going to be taken care of. And that's why, and she testifies, when she's walking through the sidewalks, she's walking with an understanding or a belief that these sidewalks have already been de-iced, have been taken care of, have been cleared of the hazard itself. That's what gets us into the elephant insurance case, because the elephant insurance case, which is out of the Supreme Court, addresses whether or not you can assume a duty. So even if Scott, Baylor, White, and Fair and its progeny applies, where there wouldn't be a duty necessarily because this is a naturally occurring condition, at the time that they take overt acts, overt steps, and make representations, which they know a regular person or reasonable person would rely on, and would rely on to their detriment, they can assume a duty that they normally wouldn't have. So by exchanging the email and by circulating the email to their staff and telling their staff, look, this is going to be taken care of, they've taken overt acts. They're taking overt acts that are to their detriment because it would actually assume a duty, but they're doing it so that way their employees can rely on this idea that they'll be safe later on in the workday.
But there's an additional element to that. It's not simply that they agreed to undertake the acts, but that the process of undertaking the acts for the benefits of others increased the risk of harm. So what increased the risk of harm other than the fact that they didn't ice the sidewalks?
What would increase the act or would increase the risk of harm is that they make the representation and then they don't follow through with it. So they're telling you we're going to be safe and we're going to do these acts, we're going to perform these acts, we're going to clear the ice, and then there's no evidence that they actually ever went through and put any kind of salt on, any kind of de-icer, any kind of sand, anything that would create traction or would eliminate the ice itself. So they take overt acts to assume a duty, but not only assume a duty to increase their employees' reliance on their representations that they're going to actually make it safer, and then they don't perform any acts to actually to go through and follow through with what they said they were going to do.
Do you have any cases? I understand, let's say, for example, they decided to clear the sidewalk, and in the process of trying to clear the sidewalk, they injured her while she was trying to walk by.
Right, that would be a negligent activity.
Do you have any cases that stand for the proposition that if you say, I'm going to do something, and then you don't do it, that increases the risk of harm in and of itself?
Not specifically within the context of like de-icing or clearing a naturally occurring condition. But the reasoning behind that analysis is it's analogous to any kind of negligence standard where you have the act, but you also have the omission, right? And so by committing to doing the act for the purposes of increasing safety, and then not going forward with that after making affirmative representations that you're going to do so, that by itself ultimately triggers the elephant analysis where there's an assumption of duty. So even if the court here, like the trial court, doesn't buy off on this idea that because there's a non-subscriber status, the Scott and White cases and the naturally occurring condition cases, plaintiff can't get around, because that case law is pretty set. Even if you believe that we can't get around it if it's naturally occurring, all that does would eliminate the existence of a duty. But at the point in time where they assume the duty and they take active steps to assume that duty, they can buy off on a duty that they normally wouldn't have. And so if they had never circulated the email, if they had never made representations, hey, we have maintenance on it, we're going to take care of it, and because we have maintenance on it and we're going to take care of it, y'all are going to be safe, they wouldn't have potentially had a duty.
I've always viewed, let's just stick with the negligent undertaking. If they go to de-ice and instead spray Pam all over it, makes it worse. That's obvious, they made it worse. Here, they didn't actually do anything to de-ice it. So the harm is still slipping on the ice. They didn't make it worse. Is just sending the email undertaking? I don't understand how it's actually they did anything to.
It's not the sending of the email, because that email is just between admin and maintenance. It's taking an email that the employees would have never seen, would have never had any knowledge of, and would have never even thought to rely on, and then circulating it and telling them you don't have to worry. That's where the undertaking actually begins. Because at that point, you're making a representation that not only do we have maintenance on it, but we're going to take care of it and they're going to get to it by the end of the day.
How does the legal duty get defined if there wasn't a legal duty to begin with? I understand how negligent undertaking can impose a duty, but if we were to write an opinion, how do we actually define that duty?
I think at the point in time when you assume that duty, that goes into a regular negligence, a regular negligent act duty. It's a regular negligence test. Was the act or the omission unreasonable, or was it reasonable or unreasonable?
My question was probably a bad question. In other words, how do we define what the scope of the duty is at that point? They didn't have a duty before, so there was no duty. We're saying there was a duty now. How is that duty? Do we take their words and just say, this is what they promised to do but didn't do it, so that's the law we're going to apply? Or is there some objective standard we apply? I'm trying to understand what your
When it
assessment.
comes to a negligent undertaking or when it comes to assumption of duty, the duty is then created or formed by the actions that actually assume the duty or the representations that are made, because that creates the context within which, one, the actors are acting, but two, we're evaluating were the acts or omissions reasonable. Finally, the idea of causation, it's in the summary judgment, it's addressed. Mrs. King talks about how she slipped on ice. The EMS records show she slipped on ice and are reported by the defendant's own employees that she slipped on ice. Her injuries and fall were caused by her slipping on ice.
Thank you.
May it please the court.
Mr. Fazio?
My friend and I definitely have a different opinion of how to parcel this case and the law as it applies. Regardless of an invitee or a licensee status, to prevail on a premise liability claim, which this is, claimant has to prove distinct separate elements. First element, actual or constructive knowledge of some condition on the premises by the owner. Second independent element, the condition posed an unreasonable risk of harm. Third independent element, the owner did not exercise reasonable care to reduce or eliminate the risk. And the fourth separate element, the owner's failure to use such care approximately caused her injuries. That's quoted all the way since from Corbin to Keach. There's modifications of those elements between invitee status and licensee status, in that the invitee status, the owner has, it's a constructive knowledge element, knew or should have known. Whereas a licensee status, it's just, did they know about the condition? That's the only separation between these elements between a licensee and an invitee. Your Honors, y'all could all rule unanimously that Ms. King or appellant was an invitee. It doesn't remove the fact is they cannot get past the independent condition that the condition posed an unreasonable risk of harm.
You would concede the evidence is at least sufficient that they were aware of a condition.
Sure, so was the appellant. And she admitted she was aware of the condition. Similar to the Gibson case that we provided in supplementation and the Scott and White case, it's undisputed. The individual knew of the slippery, dangerous condition before she slipped and fell on the ice. What I'm getting at, Your Honors, is that Ms. King was a licensee at the time of the incident because the Parabone case, which is an employer case, says that once that individual is off the clock, they become a licensee. And if they're on the premises, there is no mutual benefit for the company. There is no evidence in this record to indicate that Appley had any type of benefit from providing free housing to the appellant on the night that she decided to voluntarily stay. No one forced her to stay. She had the right to go home, and she didn't take that opportunity. So there was no requirement at all, no mutual benefit at all. So based on Parabone, Your Honors, This court and the trial court was correct in finding that she was a licensee and not an invitee for the like there's no mutual benefit.
One of the issues in this case is obviously the procedural posture, which is we got here by a summary judgment. And when we're assessing the summary judgment evidence, we've got to draw all reasonable inferences in her favor. Under these circumstances, given the storm, the fact that she was working in the COVID unit at the time in those circumstances, is there an inference that can be drawn that your client benefited from having her available when they needed her?
No, Your Honor, because number one, there's no evidence of that in the record, right? And you can have evidence all you want, but you still have to have evidence, Your Honor, to raise a fact issue. And there was none of that, Your Honor, provided by appellant in this record. And second, again, Your Honor, hypothetically, not only, well, let me state this. The appellant tells us that she could not do anything but stay there. And that's incorrect. Your Honor, as we argued, that she could have asked for assistance to help her go from building A to building B. She could have shoveled the snow herself had she wanted to, or put de-icer on the ice had she wanted to. So to the extent that they make an argument somehow that we forced her to walk in a specific area is not true. It's not in the record. We didn't tell her how to get from point A to point B. She chose that on her own, knowing that there was a slippery condition that existed, an open and obvious dangerous condition, which the Scott and White case
Was
and
there an
the case.
alternate route she could have taken?
Your Honor, the evidence is not. There's nothing in the record. I mean, I'm assuming it's a large area, right? I mean, she could have walked on the yard, I guess. She could have walked anywhere she wanted to. The fact is, we didn't force her to walk in the manner or the area in which she walked when she slipped and fell.
Any idea what the WF means in the email?
I do not know that, Your Honor, and I want to address that argument as well on negligent undertaking. The Supreme Court case in the Nile case, which is a social host liability case, which they refer to believe that it supports the argument, proves our argument. Supreme Court held that if there's no legal duty, there is no negligent undertaking claim as a matter of law. In the Nile case, social host, there's no legal duty for a host to prevent a guest from driving home drunk. Court said no negligent undertaking as a matter of law. In this case, based on Austin versus Kroger, based on the Goss case, there is no legal duty, even if you assume an invitee non-subscriber employment status, for a non-subscriber to warn of an open and obvious condition. That's in Austin Kroger, and that's in the Brickshower-Goss case. And that's exactly what we have here. We have an open and obvious condition, Your Honor. So there is no legal duty. Since there's no legal duty for us to warn, there's no negligent undertaking on our part.
I thought opposing counsel was saying just a minute ago that even if there's not a legal duty, that your client created a legal duty by affirmative statements that they were going to clean the sidewalk off, and then the neighbor did it.
That's not correct, Your Honor. Number one, that email doesn't make any type of assurances. Number two, appellant admits that she wasn't even aware of this email. So how could she have relied on that email to impose a negligent undertaking claim upon our part? And number three, as in the Scott and White case and the Gibson case.
You would agree with me, though, a duty to warn is different from a duty to make safe. For example, you could have sent an email that said, hey, there's ice. Kind of been dumb because it's open and obvious. But the email possibly says, we'll do our best to clean it. That's almost like assuming a duty to make it safe, unlike the Nile case and social host.
No, Your Honor, because those are not mutually exclusive. There's a case, State versus Williams, that says either warn or make safe in terms of a premise liability claim. That's where you don't have a duty to warn or make safe if it's an open and obvious condition. Your Honor,
Let me extend what Justice Yarbrough, I think, is asking, though. You could have sent out an email that said, don't slip. And I think there are a few cases from the Texas Supreme Court that have said simply providing that warning, even though it's snow, would be sufficient to warn somebody of the conditions. But if they undertake the responsibility, or if they say they're going to undertake the responsibility to clear it the best we can, does that not mean they need to clear it the best they can?
No, Your Honor, because that question is directly answered in the Scott and White case and the Gibson case. I'll quote, however, salting, shoveling, or applying a chemical de-icer to a natural ice accumulation does not transform it into an unnatural one, right? So we have no duty, and even if we had a duty, and even if we went out there and de-iced and shoveled, that does not change the fact that the ice and the snow is a natural accumulation, which, as the Supreme Court's held, is not an unreasonable risk of harm as a matter of law, an independent element of a premise liability claim.
But that's not an independent element of negligent undertaking. A condition of the premises.
You got to have a duty first before you have a negligent undertaking. There's no duty for us to provide a notice of an open and obvious condition.
Is a negligent undertaking a separate theory of tort? It seems like you can have a negligent undertaking separate and apart from a premises liability claim. I agree I'm going to do something that has nothing to do with the premises, and my agreement to undertake that causes you injury. Is there an independent theory of liability that even if you win on premises liability, you lose on a negligent undertaking?
I've never seen one, Your Honor. The cases cited by appellant one's a surety insurance issue related to indemnity, and then the Now case, which proves our point, that if there's no legal duty, you can't have a negligent undertaking cause of action. And again, Your Honor, what else could we have done, even if we sent out an email saying we're going to shovel, de-ice, blah, 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 blah. The Supreme Court and the Gibson Court says that doesn't change the fact, doesn't make it an unnatural condition, right? We couldn't do anything else. And so to that extent, element 2 of the premise liability claim is gone, regardless of whether you find there, again, licensee, invitee, whether we warn them, didn't warn them, doesn't matter. As a matter of law based on Scott, and Scott, there is no necessary use exception, Your Honor, because again, we didn't instruct her or tell her that she had to go the route that she walked. We didn't make her go that way. She decided to go that way in and of itself. And also, Your Honor, walking to one building to another is not an intrinsic part of the job duty as detailed for the necessary use exception as cited in the Austin versus Kroger case. This is not applicable at all. Let's see. I want to talk about approximate cause. Your Honor, in this case, the plaintiff attached unverified, unauthenticated medical records to establish causation. We objected. The trial court sustained our objection based upon the documents not being authenticated. And as an independent reason for granting summary judgment, found that there was no evidence of proximate cause between the alleged incident and her injuries as required by the Supreme Court in the cases that we cited, specifically the Leach case that says you've got to have medical testimony that connects the two between a injury-causing event and the subsequent injuries. Again, they didn't authenticate the records properly.
I agree with you that those records may be necessary for proving the extent of your injury and for proving damages. Isn't it enough if she testifies that she fell? That would be the injury, right?
Well, the fall isn't an injury in and of itself. It's got to be manifested by something. Like she broke her bone. She did this. She did that, and that's what's identified in the medical record, and that's what they're trying to attempt.
I know the record is in dispute, but what if she had said, "I fell and it hurt"?
That isn't in and of itself a causable, sustainable injury that you can be awarded damages on, Your Honor. You have to have concrete proof of of evidence of what caused your injury or what injury you sustained, rather than I just hurt. Anything else, Your Honor? If I might, Your Honor, if I could speak to the law students. In 1988, I had the privilege of being selected as a briefing attorney to the Chief Justice Curtis Brown on the 14th Court of Appeals in Houston. It was the best legal experience I've ever had in my entire life. I strongly encourage any law student to do work for a court. It's a necessary public service, and you'll get invaluable assistance, invaluable experience. If you please try to avoid the big bucks if you can, and do work for the court. You'll never regret it. And with that, as Chief Justice Brown taught me so long ago, when you're done talking, sit down. So I'm going to sit down. Thank you.
Thank you. Go ahead, counsel.
Justice Yarbrough, to answer your question, I didn't realize you were asking it originally. The WF in the email is the Wildflower Building. So I believe it's going to be court record pages 80 to 82. Mrs. King's asked specifically how you get between the two buildings, and she explains that one of the buildings is the main building. The building where she was staying in was the Wildflower Building. So that email is pertinent, not only because it's addressing the premises, but it's addressing specifically the way you get from the main building to the Wildflower Building.
Is there evidence in the record that she was aware of the email?
Yes, so she talks about in the email, and that's within 87 to 89, where not only did they have the email, but then admin and maintenance staff or janitorial staff, different than the maintenance staff working on the grounds outside, they were actually circulating the email, showing the employees the email and talking about the email itself. But specifically looking at 81 to 82, because you're asking about the Wildflower Building in the different ways and the necessary use, there is a bunch of testimony where they're asking her to map out the premises, to talk about how you get from one building to the other. The back side of the buildings going from one way to the other isn't a paved sidewalk, and it's actually sloped. Ms. King also talks about how previously she fell on that slope when she was walking between the two buildings the back way. So one, you have this email saying the path to the main building and Wildflower is going to be protected. That's why she's using that. But two, the other way is not actually even a sidewalk or anything. This is the only way to get from the two from there.
United scaffolding case
Yes.
generally says, hey, if you have a dangerous condition, you're limited to the premises liability. And they kind of get rid of saying you can't have both a premises liability and a negligent activity case. It says nothing about negligent undertaking.
Correct.
How would we write an opinion to not include negligent undertaking along with negligent activity?
Because the negligent undertake, so specifically when you look at United Scaffolding and they talk about the negligent activity, there has to be some kind of contemporaneous or present act going on with the actual occurrence of itself. The negligent undertaking is different because one, it deals specifically with the failure to actually act on the undertaking, and as we discussed before, the undertaking begins at the point in time where you're making representations to the staff that you're actually going to make it safe. And so the undertaking, there's a contemporaneous act significantly, it's from a time standpoint, is going to be attenuated from the actual fall, but that undertaking began 5-6 hours earlier. Specifically looking at the causation element that Mr. Fazio addressed, he says that the medical records are not, they shouldn't be considered. One, there's no order that gets rid of those medical records. But two, Mrs. King testifies, it's actually cited to in our brief as well as a summary judgment response. As a result of this fall, she fell, she passed out, she came to, and then had to spend 45 minutes crawling into the facility so someone could actually see her. In addition to breaking her hip, which what the medical records establish, she also suffered severe hypothermia, severe frostbite. She testifies, it's cited to in the record, that she lost her hair, she lost skin on her fingertips, she lost skin on her face, as well as her body. All of that testimony cited to within the record, that's sufficient enough at least to show some kind of causation of an injury occurring.
Like, what do you say in response to Mr. Fazio's argument, which is this, that even if there was a duty to clear the sidewalk or clear this area and they didn't do it, that it doesn't matter because under Scott and White, snow was a naturally occurring condition, and so whether it was partially melted or not melted or anything at all, it doesn't matter because it just takes us back to the fact that snow is a natural occurring.
That goes specifically to the negligent undertaking case and the elephant insurance case. So Mr. Fazio explains or says that if the duty never existed, you can't assume a duty or undertake the duty. But in the elephant insurance case, the assurity case, in that instance, there was no duty because the duties are tied by the contracts of the insurance contracts or the contracts between the parties. Elephant insurance makes representations to their insureds that they're going to actually create indemnity insurance or provide additional insurance to protect their insureds. They don't actually do that. Contractually, they would have never had that duty. That duty is not created in common law. It is only created in contract. Their original contracts don't have that specific duty, but elephant insurance did made representations to their insurers that they were going to provide that additional coverage, which wasn't addressed within the contract. And it was found that they actually did have that duty because they assumed that duty.
This is just so we're clear, this is the elephant insurance case. Is this the same elephant insurance case that came out of the car accident that was on the side of the road where the agent told him to get out of or told the woman to get out of the car and to take photographs of the accident? Because I thought in that case, the Texas Supreme Court said there was no duty because essentially she walked into traffic on her own, or that her husband did.
So there was no duty because of what I'll answer your question, Your Honor. So there was no duty for the actions of getting out of the road, but there was duty of additional, there would have been additional coverage within that duty if there's representations or promises to provide the additional coverage, and then the insurance company doesn't go forth and actually provide that coverage. So while the duty would exist in contract law or is limited to what the contract says, you can assume additional duties if you make promises to provide extra coverage and then you don't actually go forward with that.
Just one more question.
Sure.
What duty would you have us write that the Craig assumed by either circulating the email or whatever? What duty would you have us say they assumed?
At the point in time that they made a representation to Mrs. King that they were going to clear the sidewalks, they had a duty to actually clear the sidewalks, or if they weren't able to safely clear the sidewalks, to then notify the staff, hey, we've tried our best, but it's still really dangerous out there. So it would go back to either one, performing the actual activity that they said they were going to do, make representations of clearing the sidewalk or making it safe, or two, at the point in time when they realize they can't either make it safe, or if they're really caught up and they just can't get time to go do that, then they have a duty to actually notify their employees, hey, we didn't get to that sidewalk, y'all gotta be safe out there. Thank you.
The case is submitted. Council, we appreciate you traveling to Lubbock to hear arguments today. And once again, we want to thank the Texas Tech University School of Law and Dean Allen and also Dean Chapman for being such gracious hosts for us today. You're excused.
Thank you, Your Honor. Good to see you again, folks.
You're not going to go out the back door?